Good morning to all of you. Welcome to Legal Matters by Sai Baba Sunkara. In this video, we are discussing the Bhopal gas leak tragedy, particularly the curative petition filed by the Government of India. I think while discussing the constitutional part, I told you that curative jurisdiction is the last remedy by the Supreme Court. After that, nothing. Normally, the case will be tried, let us assume, in the magistrate court. You can go for appeal in the trial district judge court, then to the high court, ultimately to the Supreme Court. You can file a review petition before the Supreme Court. And later, that is the final, really. But later, on two grounds, you can approach the Supreme Court of India. Under Article 137, Article 137 says the review power of the Supreme Court. It can review its own judgments. So, according to Article 137, even though it is not specifically mentioned as curative petition, the Supreme Court can review its order. So that is the last remedy. In Bhopal gas leakage case, a curative petition was filed in the year 2010. Actually, the origin of the case, of course, it may be there age old, but as far as I know, in the very famous case of Ashok Hurra versus Rupa Hurra, 2002, the curative petition was allowed on two grounds. Number one, the principles of natural justice, or the other person was not given a chance to be heard, not given an opportunity to be heard. Second is, the judges are biased. I think only under these two grounds, the curative petition will be allowed. It was allowed because in the case of Ashok Hurra, actually it was a matrimonial dispute. In the lower court, she agreed for divorce. Later, she changed her mind. Lot of things happened. So, since she was not given an opportunity to be heard, curative petition was allowed. So it is one of the, just like rarest of rare cases for giving death penalty, it is one of the rare remedies evolved by the Constitution bench. Right. So here please remember, in this connection as regards the Bhopal gas leak tragedy, I told you in detail, almost I have taken two classes for this Bhopal gas leak. It's a man-made disaster, no doubt environmental disaster, gas leakage of that methyl isocyanate gas, ultimately resulting in the death of, at that time we calculated the deaths as I think 3,000 or 3,000 deaths. Then 70 lakhs of people, 70,000 people, they have been injured. But now the figures have risen. Now the figures have come to, death is, instead of 3,000, it has come to 5,000. Whereas the injuries from 5,000 to 50,000 to 70,000. Anyway, since the number of instances have been increased and since the number of injured persons have been noted, then the Government of India filed a curative petition. So let us have a brief facts of the incident. You may be knowing, on December 1984, on 2 days, the methyl isocyanate gas from Union Carbide Company, which was the manufacturer of the so-called insecticides at that particular time, and the effect of the leakage spread to the nearby areas, and so many people have been affected. So therefore, a case has been registered against the owner of the Union Carbide Company, Mr. Anderson. 304A IPC case was registered. Of course, he was released on bail. 304A is bailable. He was sent back to USA, and Government of India filed a case in New York Federal Court, but they have returned it basing on the principle of just necessitatis, because the entire thing happened in India, and government filed a case in Bhopal court where they have awarded 350 crores. Then the matter went to the High Court. It has reduced to 250. Ultimately, in the year 1989, Supreme Court asked UGC, that is Union Carbide Company, and the Government of India to come to a settlement, as per which I think $450 billion have been sanctioned. Company paid that amount also. This is the story. But later, lot of changes. Still there is a hospital in during the Corona period. I told you that the designated hospital of Bhopal gas leak victims, it was converted into Corona hospital, but due to the resentment by so many people, because still people are suffering, it has been rechristened as the Bhopal gas hospital. Such is the severity of the incident. So since the amount of 450 billions is not sufficient, the Government of India filed a curative petition. Now it has come before the 5 judges bench, constitutional bench, 5 judges bench, that is Sanjay Kishan Kaul, consisting of Sanjay Kishan Kaul, Sanjeev Khanna, Justice, Abhay Srinivas Lokha, Vikramnath and J.K. Malleshwari. They have been hearing the arguments for 3 days, and I think they have kept the judgment in reserve. So you can read the cases: Union of India and others versus Union Carbide Company and others, in curative petition numbers 345 to 347 by 2010. So you have to remember that the curative petition was filed in the year 2010. The agreement was in 1989. So after 19 years, our people have filed the curative petition. Ultimately, it has come after 12 years. Even though they filed in 2010, the matter has come. At the outset, I think a day before yesterday, I have seen the papers. UCC, represented by Shri Harish K. Salve, he clearly stated UGC will not pay a farthing. That means oka chilli paisa kuda ichedi ledu. Because the settlement of 1919 was already observed, or it was complied with. The government and the Union Carbide Company, they have come to a settlement. Yes, according to settlement, the amount was paid. Why should they pay extra? But Attorney General Sri S. Venkatramani, R. Venkatramani, he tried to inform the court that there is a necessity to reopen the so-called Bhopal case, to take into consideration of it. So, because even though it occurred about 30 years back, but please remember, there have been increasing the number of the so-called reported deaths and also the so-called injured persons. Still they are suffering. So at the outset, Sanjay Kishan Kaul, he said, the court cannot act as a knight, KNIGST. The court cannot act as a knight in shining the armor, granting panacea. So far, we are bound by the constitutional constrictions of the law. Already you have effected compromise. Now you want say more money. That too after 22 years back. How can we take up the case? This is the first objection raised by the Supreme Court of India. Of course, our Attorney General, he tried to convince, and on their behalf, Mrs. Nandi, I think she is a lady advocate, she also stated that the number of people, they are increasing, they need some care. So government, of course, it is there to grant, but according to the that act, I think Bhopal gas leak within brackets, Processing of Claims Act 1985. So the center should evolve a formality to actually just get victims solace. So in that connection, in the year 1989 or so, government, Supreme Court directed the Government of India to take 1 lakh insurances, so that if the people are still having the problems, they can get insurance. But Supreme Court did not do so. Anyway, the matters are standing like this. So, and now Supreme Court says we will not try the curative plea like a suit. We will complete it as early as possible. So anyway, So here, if they are entitled more, please pay them. But what do you need petition? Look at the Hurrah jurisdiction, Justice Moka pointed out. Right? So let us hope that some justice, so because it is left open a considerable avenue for the relook of 1984 incident. But anyway, let us see what will happen. But why I have made these videos, you must all know regarding the curative petition, regarding Article 137, regarding Rupa Hurrah case, regarding Bhopal gas present stage. So if you know this much from this video, it will be sufficient. Thank you. Bye.